Welcome back to Courtroom Clapback, guys. Today we are going into Judge Aaron's courtroom where the people versus Samuel Hill, his third offense on domestic violence. Now this guy has 4 prior felonies and 14 misdemeanors. He's looking for Judge Aaron to have mercy. Do you think Judge Aaron should do that today? I'm going to let you be the judge of that, and I'm going to watch for your comments below, and I'll let you know what I think at the end of the video. But for right now, grab your popcorn because court is now in session.
All right, and next we can call People v. Samuel Hill, file 26-7155FH. Counsel, you want to state your appearances?
Melissa Goodrich, Wayne County Prosecutor.
And Fred Filippa here with Mr. Hill.
All right, and we're here for sentencing on a charge of domestic violence third offense. It's a 5-year statutory maximum, and the advisory guidelines had been scored at 7 to 23 months. Mr. Filippa, have you had a chance to review the report and recommendations with your client?
I have, as to both. The only comment may come down more to arguments with regards to the use of the scram through all of this. Mr. Hill continues to deny recent use of alcohol, although no alcohol has been a lifetime issue. And Mr. Hill's father even called me earlier today saying, mirroring those comments, that he's not seen recent, past couple of years, alcohol consumption by Mr. Hill. There's a recommendation for a scram, whether that be a long-term thing with probation, short-term. Mr. Hill is in the masonry trades, and he told me that he did fine with the scram before, but it does cause some irritation with the boots and skin and having that on.
Okay, and do you have any scoring challenges to the guidelines? Ms. Goodrich, do you have any additions, corrections, or scoring challenges?
No, Your Honor.
I did have a couple scoring issues I wanted to hear from counsel about. The first was under offense variable, and this is mostly the victim's written impact statements. I think supplements the information in the pre-sentence report and causes me to want to re-examine offense variables 3 and 4. Offense variable 3 is physical injury to a victim. It was scored at 5 points for bodily injury not requiring medical treatment. And I wonder whether the victim's description of the assault and her injuries and the effect on it afterwards, the physical effect about the pain from the headaches, likely concussion, things of that nature, whether that would support a score of 10 points for OB3 for bodily injury requiring medical treatment. I guess I'll hear from you first, Mr. Filippa.
Does your report indicate that she went to the hospital?
She did not, but the guidelines do say that requiring medical treatment refers to the necessity for treatment and not the victim's success in obtaining treatment.
I'm trying to think to the concussion protocol. I think it's really just staying awake. I'm not sure that necessitates medical treatment in an ideal world.
Okay, Ms. Goodrich.
Your Honor, based on her description of the victim's statement that her eyes were red with blood, received pain from headaches, and slept a lot with a concussion. I think that if law enforcement was aware at that time that it occurred, that they'd be recommending medical treatment.
In fact, I'm particularly looking at excuse me, the victim's description that that Mr. Hill had punched her with a closed fist above her left eye. She says, "My eye was swollen completely shut. I did not seek medical help because I was afraid of getting him into trouble." And then talks about later when she was able to open her eye, it was red with blood for a month, pain from headaches, slept a lot, likely concussion, but particularly because she said that she, would have sought medical help except for fear of getting the defendant in trouble. I think that's the kind of injury that I agree with the prosecutor. If the police had been aware of that at the time, they certainly would have called medical attention for her. So I think that on a preponderance standard would support scoring OB3 at 10 points rather than 5. So I'll do so. I also wonder, again, based on the victim's written impact statement, whether offense variable 4, which was scored at 0, should be scored at 10 points for a serious psychological injury requiring professional treatment occurring to a victim. Mr. Philippa, I'll hear from you again.
I think as a practical matter, we're already up to a 10 to 23 guideline shift with the first 5 points from OV3 that were just added. Frankly, I can see both people requiring psychological help. I know Ms. Hill is, I know Amy still is in the courtroom. I don't know if she did a name change as part of the divorce. So I would defer to the court. I certainly don't want to cause any waves.
Hey, Ms. Goodrich.
I would ask the court to score that based on her victim impact statements that she was hurting physically and emotionally. It ended up resulting in some treatment for that.
Okay, and the victim did describe the mental distress, and then that she had suffered from this assault, as well as other incidents of abuse that she had disclosed. She also described that she, as a result, had engaged in counseling for mental distress, anxiety. So I think that does support on a preponderance scoring OB4 at 10 points. So that brings the total OB from 5 points to 20 points, OB level from 1 to 2, and the guideline range from 7 to 23 to 10 to 23. Okay, Mr. Philippa, anything you want to say on behalf of your client?
As for allocution?
Yes, sir.
Thank you, Your Honor. As the court no doubt felt, reading the victim impact statement, that is a very powerful, profound statement. Ultimately, Ms. Hill goes on at the conclusion to recommend probation, fines and costs, things of that nature, consistent with the plea and sentence agreement in this matter, which Ms. Goodrich no doubt had in her awareness at the time of offering that plea offer. Also, through reading the PSI, I'm sure the court was aware that Mr. Hill has been going through some anguish of his own in the past several months. And I can echo that has been a sincere anguish that he has had in multiple phone calls he's had with me, both in contemplation of divorce, pre-charging, and then post-charging. I think Agent Purvis hit the nail on the head, though, that this was a unique set of charges to be filed and brought years after law enforcement could have been called. In fact, I think they were called on several occasions, and probably is not all too uncharacteristic of DV situations. Conflicting reports were given. Mr. Hill has a number of very strong attributes. He's a hard worker. He has voiced his care for Amy, or Ms. Hill. And I'm not sure what her is this Ms. Hill after the divorce.
I don't know, but yeah, just say the victim or the complainant. That's certainly worked just fine.
Okay. They try to personalize. They teach us to personalize these things and include people's names. So I'm sure when you're on the bench, you hear hundreds of people's names.
I know. I'm just not sure how much she wants us to parade her name around today.
Very much. I certainly don't want to do that either. And so we are.
You don't have the right to her name anymore, Mr. Hill. You don't have any right over her. Go ahead.
And he understands that he has no right to her. Echoing from my comments with regards to the pre-sentence report, I would ask that he only be placed on random testing, and that if it becomes a problem, then, which I don't think it's going to be a problem, Mr. Hill denies any alcohol use recently. He understands that he's had many good opportunities in his life ruined because of alcohol. He has denied recent alcohol use. His father called me about 12 o'clock today, repeating that Sam has not been using alcohol recently, that the SPRAM is certainly a standard term and condition of the probation.
I don't even see that as a requested term, to be honest. I'm not sure if I missed that. I don't see the electronic.
On the page 1, CFJ 284.
And if it's not, that's perfect. You know, maybe not have been in.
Oh, he should be given a condition for a scram if no jail is ordered. Okay, but it wasn't one of the requested conditions in the probation order. Okay. Okay.
Mr. Hill, is there anything you want to say? No, sir. And I think you said that yesterday when we talked that you don't like public speaking, you don't like talking about your feelings. But I do know you've mentioned many times you feel bad that the relationship worked out the way it did in your role and all of that. So that's
okay.
all.
All right, thank you. So yeah, Mr. Hill, you don't have to make a statement. I don't hold against you if you don't, but you're welcome to. Okay. All right, Ms. Goodrich, any recommendations from the people?
Thank you, Your Honor. The nature of this complaint, as discussed, was a delayed reporting of a history of domestic violence in this relationship, where the striking of the defendant against the victim had caused bruising in the past, and the violence happened multiple times. As is common with a lot of domestic violence victims, she was hesitant to proceed with police involvement or not. She was, however, involved in this plea taking process and is present here today, but wishes to rely on her victim statement. The defendant is 51 years old. He has 4 prior felonies, 14 misdemeanors. He's employed with the GED. I did see in the PSI that he has sought some mental health and dependence issue treatment and was honest about battling a long history of alcohol abuse and requests that be part of the probation. The guidelines here are 10 to 23. The plea agreement was for no immediate jail with probation, which would address the mental health and substance abuse issues discussed in the PSI, but also provide, I understand it would be a downward departure of the court, but this plea would also provide enough time that if he was to violate his probation, that incarceration would be available. The PSI recommendation is for 18 months, and if people agree, the additional request would be that no contact order continue. And I did agree with that recommendation for an alcohol tether. I understand that it's inconvenient, and he's stating now that he doesn't drink, but that certainly would provide assurance to the probation officer, given the statements by the victim and statements submitted to the court. Thank you.
All right, thank you. Well, Mr. Hill, please stand for the court sentence. All right, well, you know, I've spent a good deal of time reviewing the sentence report and the impact statement in this case. Mr. Hill, you're 51 years of age. You have 4 prior felonies. Most of those, well, I think all of them were drunk driving felonies, or maybe a couple of things, but long-standing alcohol issues and long-standing, frankly, anger issues. Otherwise, you wouldn't be here on a 3rd offense domestic violence. Do you know how many convictions for domestic violence most men accumulate in their lifetime, Mr. Hill?
0.
Yeah, that'd be exactly right. So I'm not sure how you get to 3 without it kind of being a feature of your personality and some character trait and defect that you need to be honest with yourself about. You know, you've always been a hard worker, but you know, so what? Right? Be a hard worker, but if you hurt those around you, I'd rather have you be unemployed and lazy and not hitting people. This is tough because I know you've had, as your attorney alluded to, and I don't want to embarrass you today by a deep dive into, but you know, you've had your own struggles since this, and I wish you the very best in navigating those issues. But you know, I don't know that that is a mitigating factor for me in determining somebody's sentence. You know, a defendant who, you know, has some self-harm issues after a crime doesn't necessarily mean that they don't get punished for that crime. And then I've got the other factor here is this was a delayed report, which is not uncommon. What's uncommon is that it gets charged, and commend the prosecutor for that. And that gets prosecuted a lot in delayed sexual abuse claims, but in domestic violence, here then the victim finally felt empowered to disclose the things that had happened during your marriage. And with your felony history and your domestic violence history and the advisory guidelines at 10 to 23 months, it's just really hard for me, Mr. Hill, to see my way to why should I grant a downward departure and give you more leniency than those guidelines would call for. I note that if you went to trial with the habitual notice and were convicted, we'd be looking at 10 to 46 months. I think there's an awfully good argument, either with or without that habitual, that this, with your history, is a prison case. Just having said all that, the most that I could see my way to today, based on this plea with no habitual, would be low end of the guidelines. So it would be my intention today, Mr. Hill, to sentence you to 24 months of probation, subject to the terms and conditions listed in the pre-sentence report, with the addition of no contact with the victim, scram tether for the first 90 days after your release from jail, and 10 days on the Sheriff's Department's work crew program. State cost of $68, crime victims assessment $130, court costs of $350, monthly supervision fee. And it'd be my intention also to sentence you to 10 months in the Sheboygan County Jail with credit for 1 day previously served. Mr. Hill, that presents you with a choice today. That does not comply with the plea agreement in this case, the sentence agreement. So that gives you two options. You can, and I'm going to give you a chance to talk to your attorney. You can choose to accept my sentence and do your 10 months and then on probation. Or you can withdraw your plea and we go back to a pretrial posture and we schedule this for a jury trial with the full charges and habitual. So I'm going to give you some time here to talk with your attorney and see if you can reach a decision. Go.
Well, Judge Aaron did not go along with the program, did he? Did you agree with his sentence? I was shocked when he added that 10 months of jail time on the end. That wasn't the prosecutor or the defense's agreement, but the judge doesn't have to go along with their agreement. And I'm thinking, Mr. Samuel Hill was thinking, what in Sam Hill just happened? But, he part of his defense is he's a good worker. And Judge Aaron said, I'd rather you be unemployed and lazy and not hit people. And that was common sense to me. So like we said, 4 prior felonies, 14 misdemeanors. So the plea deal was no jail time, just probation for 18 months. And Judge Aaron was not going along with that. I mean, his ex, when he hit her in the eye, it was blood-filled for a month. That was a hard, violent hit. And Judge Aaron just was not going to go along with the program. Did you guys agree with it? So 10 months in jail, along with 24 months of probation, 10 days of work, the work release program. He'll be picking up trash on the side of the road for 10 days. You go, Judge Aaron. I agree with it. How about you guys? So let me know what you think. Drop your comments and I will read them. And until next time when we meet right here for our next case, court is now adjourned.